5 seconds to go. Start. This court in Sayyid Abdul Qadir versus State of Bihar held as follows. Undoubtedly, the excess amount that has been paid to the appellant teachers was not because of any misrepresentation or fraud on their part, and the appellants also had no knowledge that the amount that was being paid to them was more than what they were entitled to. It would not be out of place to mention here that the finance department had in its counter affidavit admitted that it was a bona fide mistake on their part. The excess payment made was the result of wrong interpretation of the rule that was applicable to them, for which the appellants cannot be held responsible. Rather, the whole confusion was because of inaction, negligence, and carelessness of the officials concerned of the government of Bihar. Learned counsel appearing on behalf of the appellant teachers submitted that majority of the beneficiaries have either retired or are on the verge of it. Keeping in view the peculiar facts and circumstances of the case at hand, and to avoid any hardship to the appellant teachers, we are of the view that no recovery of the amount that has been paid in excess to the appellant teachers should be made. Para. Premised on the legal proposition considered above, namely whether on the touchstone of equity and arbitrariness, the extract of the judgment reproduced above culls out yet another consideration which would make the process of recovery iniquitous and arbitrary. It is apparent from the conclusions drawn in Sayyid Abdul Qadir's case that recovery of excess payments made from employees who have retired from service or are close to their retirement would entail extremely harsh consequences, overweighing the monetary gains by the employer. It cannot be forgotten that a retired employee or an employee about to retire is a class apart from those who have sufficient service to their credit before their retirement. Needless to mention that at retirement an employee is past his youth. His needs are far in excess of what they were when he was younger. Despite that, his earnings have substantially dwindled. Keeping the aforesaid circumstances in mind, we are satisfied that recovery would be iniquitous and arbitrary. If it is sought to be made after the date of retirement or soon before retirement, a period within 1 year from the date of superannuation should be treated as iniquitous. As such, para Mr. Prem Singh, learned counsel for the appellant, contended that the previous scale of Rs 220-550 to which the appellant was entitled became Rs 700-1600 since the appellant had been granted that scale of pay in relaxation of the educational qualification. The High Court was therefore not right in dismissing the writ petition. We do not find any force in this contention. It is seen that the government, in consultation with the University Grants Commission, had revised the pay scale of a librarian working in the colleges to Rs 700-1600, but they insisted upon the minimum educational qualification of first or second class, MA, MSc, MCom, plus a first or second class BLIB science or a diploma in library science. The relaxation given was only as regards obtaining first or second class in the prescribed educational qualification, but not relaxation in the educational qualification itself. Admittedly, the appellant does not possess the required educational qualifications. Under the circumstances, the appellant would not be entitled to the relaxation. The principal erred in granting him the relaxation, since the date of relaxation the appellant had been paid his salary on the revised scale. Para. However, it is not on account of any misrepresentation made by the appellant that the benefit of the higher pay scale was given to him, but by wrong construction made by the principal, for which the appellant cannot be held to be at fault. Under the circumstances, the amount paid till date may not be recovered from the appellant. The principle of equal pay for equal work would not apply to the scales prescribed by the University Grants Commission. The appeal is allowed partly without any order as to cost. It would be pertinent to mention that librarians were equated with lecturers for the grant of the pay scale of Rs 700-1600. The above pay parity would extend to librarians subject to the condition that they possessed the prescribed minimum educational qualification. For those librarians appointed prior to 3 12.1972. The educational qualifications were relaxed in Sahib Ram Verma's case. A mistake was committed by wrongly extending to the appellants the revised pay scale by relaxing the prescribed educational qualifications, even though the concerned appellants were ineligible for the same. The concerned appellants were held not eligible for the higher scale by applying the principle of equal pay for equal work. This court, in the above circumstances, did not allow the recovery of the excess payment. This was apparently done because court felt that the employees were entitled to wages. Stop.